next case is Niederst versus Niederst et al. In this particular case, each party will have 15 minutes to argue as always, but because we have appeals and cross appeals, I want you both to understand, we're just having that 15 minutes, you'll have to address both appeals during your time. So when you start, you'll have to address, however you want to break it up, address your appeal and your response to their appeal during that time. So you do understand that, Council. And then same thing when you're up, you'll have to both address his appeal and whatever you want to say about your own appeal, however you decide to divide that time, that's up to both of you. But it will be that 15 minutes, and that is the time we'll have today. Council, how long would you like to reserve for rebuttal?
5 minutes, Your Honor.
Okay. Do you have any questions? I'm sorry, I cut
No,
it.
sir. That was going to be my question.
Okay, very good. I will be taking note of that up here. If you look over there to the clock, I would suggest you pay close attention to the top one. When that gets to 5 minutes left by the top one, you're in your rebuttal time.
Yes, Your
I
Honor.
likely will not mess around with the bottom one on the bottom for 5 minutes for rebuttal time. If you go past the time, that's fine, it'll just come off your rebuttal time. So if you feel you have things to tell us, you may do so, but at that point, it'll come off your rebuttal time. The arguments are being recorded. When you present your argument, please come up to the podium. Please make sure you stay behind the podium. We're visually recording as well as audio, and we lose you a little bit if you go back and forth from the podium. So please stay behind the podium and speak loud enough so we can hear you when the recording can pick you up. You should not use the name of any child, minor, or victim during your argument. I don't know if we have that in this case, but if you were, please use initials or something other than a child, minor, or victim. That's what it comes. With that, the court has read your brief. Ready to proceed whenever you are.
Thank you, Your Honor.
Thank you.
May it please the court. My name is John Burke, and I represent the appellants in this case, Brenda Niederst and her related entities. That's my client, Brenda Niederst, right there. This case is in regard to a 5-count complaint that was filed by the appellants that alleged a number of different causes of action. One, it was a breach of contract, which was a breach of the settlement agreement that had been entered into 2016-2017 between some of the parties. Two, fraud in the inducement in entering into that original settlement agreement. Breaches of fiduciary duty, unjust enrichment, and conversion. The defendant appellees answered the complaint and filed 5 counterclaims of their own. The same breach of settlement agreement claim, breach of contract, abuse of process, malicious prosecution, a claim for injunctive relief, and a claim alleging fraudulent tax filing. Discovery commenced, and thousands of documents were exchanged and produced and subpoenaed. The defendant appellees filed a motion for summary judgment, essentially contending that the 2016-2017 settlement agreement that had been entered into by the parties extinguished all of the appellants' claims. They also asked the trial court to grant them summary judgment on their own breach of contract claim. The trial court denied the motion for summary judgment for the appellees on their claims of breach of contract, stating that issues of fact precluded the granting of summary judgment on the appellees' breach of contract claim. Remarkably, on the same set of facts, disputed and undisputed, the trial court granted the summary judgment on my client's claims for breach of contract, i.e. breach of the settlement agreement, fraud in the inducement, breach of fiduciary duty. The basis of our argument really is if the breach of contract claim that they alleged, which was essentially similar to ours, if there were factual issues that prevented that, there should have been factual issues that prevented summary judgment being granted in our case. So what happened then is the case went to trial, but solely on the defendant appellee's claims. And they were then allowed to present evidence on breach of contract. Prior to the case proceeding, they dismissed their abuse of process claim, but they proceeded with their malicious prosecution claim and their fraudulent tax filing claim. This whole lawsuit is a very unfortunate set of facts because it involves family members who have devolved into what is now probably close to 10 years of litigation between these parties. Brenda and her brother Mark entered into these different partnerships, LLCs, and there's numerous different layers to these whole things. But essentially, the two of them owned two different apartment complexes, one in Cuyahoga Falls called Niederst Portage Towers, and then one called down in Brunswick. So they have this dispute, and a lawsuit is filed in, I think, 2016 by Mark, alleging that Brenda has done all these things. Counterclaims ensue, and the two parties attempt to come to an agreement. The entire time that these business relationships had gone on, it had been Mark, and not Brenda, who was the managing member of these LLCs. He had complete control over the finances, he had complete control over the buildings, he did everything, and he also prevented Brenda from viewing many of these different documents and information. So when she entered into this settlement agreement in 2016, 2017, she believed that she had been given accurate information about what partnership, what LLC owned what percentages of what buildings, that everything had been paid accordingly, that everything had been accounted accordingly over the many, many years of the relationship. Well, she comes to find out that that wasn't the case. And those were the allegations that we made in our complaint that was initially filed in 2020, dismissed, and then refiled timely in January of 2021.
The trial court below said, in essence, that it seemed to me when it came to responding to the summary judgment motion on behalf of Brenda, you didn't have any new information. So what was new after the 2016 agreement? What was, when you came to court, here's the new stuff that the trial court missed when it was on the summary judgment? Sure,
that was one of the things that really befuddled us, because we did produce all sorts of information. We produced and filed with the court an affidavit from Brenda that I think was 100 paragraphs some long, where she outlined specifically, and she did admit that she had some suspicions but wasn't aware. And during the course of the litigation, we obtained all sorts of information from banks that showed that
2020 litigation, I take it when you say that.
Yeah, so actually
2016 litigation.
Not the 2016, Your Honor. It's actually 2021, because it was initially filed, actually it's 2022, my apologies. It was initially filed in 2020, voluntarily dismissed by other counsel in January of 21, timely refiled in 2022. Okay? So she put together and did extensive work gathering information through subpoenas from financial institutions, accountants. We finally got a hold of all of the banking records, all of which she hadn't been given and wasn't allowed to see during the course of their business relationship. So all of that information was new. She had specifics about the bank accounts where you could demonstrate that they were taking money that should have been put into one account and put into another account, trying to build up the value of one building versus the other building.
Counsel, can I interrupt you? And I apologize, I'm a little under the weather, but I'll try to speak up here. I'm a little confused because how is that information not available to you in 2016? Because you're talking about information, I think anyway, correct me if I'm wrong, you're talking about information that was before the settlement agreement. Now you're saying you found out this information recently because of this lawsuit.
Correct.
But that information all pertains to actions that were taken prior to the settlement agreement, correct?
Some of it does, some of it was immediately post-settlement agreement, but she was not able to get that information. That information wasn't provided to her, as was a duty of the guy
Well, you
who
were
was
involved
running.
in litigation, why couldn't you just subpoenaed it? Why couldn't you have filed a discovery request?
I wasn't.
I understand that, I'm just talking generically.
I understand that that's the you you're using there, Your Honor. She wasn't able to get that information, Mark wasn't providing that information, but more importantly, here's the important part. She believed, based upon what Mark was telling her, that he had provided all of the information, that he had done everything correctly. This not only was her business partner, but it was her brother. And all of the information that
Her brother the suitor.
her brother, that is very, very true, Your Honor.
So
Her
why
brother
would
was
she
sued.
ask for discovery of all this?
And I believe she did, and I don't think she got all of the information that she had requested in that case. And again, I was not counsel in that case. But also, after the settlement agreement was effectuated, there were a number of things that were supposed to be done that weren't done. Information that was supposed to be applied and supplied that wasn't. Tax records that were supposed to be corrected and amended. Documents and financials and true-ups of the relationship between these people, showing the true values and where all these monies had gone. And they're also just up to the point where the case was being resolved. There were all sorts of actions.
1 minute left, Counsel. Sorry to interrupt.
Thank you, Your Honor. I greatly appreciate that. The crux of our case really is Brenda was not given her day in court to prove that A, Mark had breached the settlement agreement. The trial court on the same facts said, oh, we can't grant their motion for summary judgment because there's disputed facts. There's disputed facts there should have been disputed facts here. Secondly, and most importantly, it was fraud in the inducement. She was fraudulently induced to enter into the settlement agreement to begin with. When you have fraud in the inducement, it doesn't relate to what was in the agreement. It relates to how you were compelled and induced into doing it. I see my first part of my time is up. Thank you. I will readdress things on my rebuttal.
Good morning, Your Honors. Mike Stavnicki for Mark Niederst and the appellee cross appellants. I'd like to reserve 3 minutes, if I could, for rebuttal.
All your time will be in your 50 minutes.
Okay, no rebuttal.
Everything in your 50
Got it.
minutes.
All right, so I'm doing the whole spiel. Got it. I mean, this case is maddening. It's just enough is enough is enough. Lawsuit after lawsuit, appeal after appeal, breach of settlement after breach of settlement. I mean, it's never ending for Mark Niederst. So suffice it to say that Brenda Niederst and her company and her agents don't honor any settlement, court judgment, court of appeals judgment. It doesn't matter. It just gets breached. It just gets litigated again and again. I'm going to quickly run through the history of this case from the former appeal that they lost. 2016, Mark and Brenda are brother and sister. They own 2 apartment complexes. They do business together. The arguments that she didn't have access to this, she didn't have access to that, completely false. We've litigated this before. Brenda refuses to sign a mortgage. Portage Towers goes into default and is threatened with receivership by the lender. Mark brings a lawsuit to compel her to sign the mortgage documents. It's simply an extension of a loan because the property is going into receivership. Nobody's got $15 million burning a hole in their pocket to pay off the existing loan. It was a refinance of the loan. Mark files that lawsuit. During that 2016 lawsuit, we settle in the fall of 2016. Mark's going to buy both properties, pay her money, she'll be gone. She reneges. Lawsuit continues. We go to private mediation with retired federal judge Dick McQuaid. The parties are in separate rooms. They are not together with alleged fraudulent inducements from Mark. Never in the same rooms. Judge McQuaid, in his handwriting, they argue it's my handwriting. It is not my handwriting. My handwriting is awful. You wouldn't be able to read anything. It's like a doctor's prescription. Judge McQuaid drafts the settlement. Initially, it was Mark was going to get Cross Creek, Brenda was going to get Portage, then she flip-flops. Mark has to take Portage, she wants Cross Creek, she makes allegations of fraud, breach of fiduciary duty, embezzlement, all of which, other than the fraud and the inducement, were counterclaims in the former lawsuit. They negotiate down how much she has to pay Mark from $1 million to $650,000. They sign a settlement. She's represented by counsel, Corman Jackson. Great, we're done. Wrong. She reneges and breaches the settlement again. We file a motion in front of Judge O'Brien to enforce the settlement. We go to court in January of 2017. She signs another settlement in Judge O'Brien's courtrooms with Corman Jackson with her. Mark is not in the room. He is out in the hall. Signs it again. Great, we're done. She breaches and reneges again. February of 2017, we file another motion to enforce the settlement, and we have a full evidentiary trial on it. She loses. She brings all these allegations in that March and April of 2017 hearing, well, represented by Corman Jackson, that Mark lied to her, that he was embezzling money, that he had fraudulently induced her to enter into it, that he was stealing credit card points, that he took a truck, all this stuff. I've done it before. She loses. Great, we're done. Wrong. She appeals. We come to this Court of Appeals. She loses again. Great, we're done. Wrong. She sues him again in 2020. She's represented now by her second counsel, David DeVorn. We file a motion to dismiss going, what are you guys doing? We've got a trial court judgment, we've got a Court of Appeals judgment, we've got a signed settlement agreement, and you've lost in every single thing. We file a motion to dismiss. He dismisses. She finds her third lawyer. She sues him again in 2022. We move, after about a year and a half of discovery, we move for summary judgment. The trial court properly granted summary judgment. Some of your Honor's questions were accurate, that all of these issues have been raised before. All of these issues, she had the ability to do discovery before. It's just the same old thing again and again and again. So there's about, pick your poison, there's about 8 different ways that the trial court's decision on summary judgment is right. They raise the, opposing counsel raises the issue, well, hey, if there was an issue of fact for us, then there should be an issue of fact for them. Wrong. Our claim for breach of the settlement is this lawsuit. It was, go away, you've released these claims and signed a settlement and litigate, but you're forcing us to incur attorney's fees and defend ourselves again, go away. That is our breach of the settlement, not some hidden mumbo-jumbo behind the scenes. 7 different ways, at least, that the trial court's decision was right. Res judicata. We've tried this case before. We won. She lost. In the trial court and in the Court of Appeals. Collateral estoppel. She raised these issues before. She lost at the trial court. She lost in 2018 in the Court of Appeals. Judgment by estoppel. The waiver in the release. The integration clause in the settlement agreement and release. The statute of limitations and the tenderback rule. Lose, 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 lose. The argument that they're making, and I don't like saying this, is patently false, that she discovered something after the settlement. First of all, we had a trial in 2017 where she raised this whole issue and she lost. As we attached in our brief in opposition, or in support of our motion for summary judgment in front of Judge McLaughlin, she has been raising these issues about Mark since 2013. When she lost the lawsuit with Mark in 2016-17 and then the appeal in 2018, she sued her lawyers, Corman Jackson. She lost that lawsuit and then appealed and lost that appeal. But the great thing about that lawsuit was she attached all of her communications with her lawyers. And we got that information, we authenticated her deposition, and it was the hangman's noose for her claims in this, that this is something new. She told her former lawyers in 2013 and 2014, a decade ago, Mark's embezzling, Mark's doing this, Mark is mixing and matching income, all of which was false. But even assuming it wasn't false, even assuming that Mark was somehow an imaginary bad guy, she knew about it a decade ago. A decade ago. Pre the settlement, pre the trial, pre this case, by a decade. So the trial court properly ruled in summary judgment, throwing out the claim I think I'd like to bring the court's attention to one paragraph in the trial court's decision. I've never seen this before. Judge McLaughlin said that the brief in opposition to the motion for summary judgment, this is the direct quote from the trial court, was shockingly lacking in factual and legal support. Shockingly lacking. And case law cited to in the brief in opposition have been overruled. Multiple cases. So they don't get 2-3 bites at the apple for what they couldn't do before. It's all much to do about nothing. Quickly touching on the tender back rule. If there was truly fraudulent inducement on this settlement, a bunch of things would have happened. A, Mark would have had to have talked to his sister. Never happened. They have not talked to each other since 2015-16, early 16. They were never in the same room when they signed the settlement with Judge McQuaid. They were never in the same room when the settlement was signed in front of Judge O'Brien in chamber. Never happened. So there can't be an inducement. But let's assume that Mark somehow induced his sister to enter into this. If you're truly trying to rescind a settlement agreement, and we didn't have all of these other factors, it was a true fraud. Someone said, I own swampland, they don't own swampland, you sign a settlement where you get the swampland, person didn't own it. It's a fraudulent inducement. They didn't possess that which they're giving to you. You have to tender back the consideration for a settlement. She has Cross Creek Apartments. She has a $25 million apartment complex. She has never offered, they've admitted they cannot tender back the apartment complex, or 56% of it, that Mark owned before. That is a requirement from the Ohio Supreme Court. The Javich case, the Haller case, you have to tender back the consideration. In their brief in opposition, they argued, well, that tender back rule only applies to tort claims. False. We filed, and sadly it's one of my cases that I lost, I filed supplemental authority from the 8th District, which is Weissman versus Blauschild. Weissman versus Blauschild is this case. Fighting amongst owners of...
Let me do this, let me get directly to your appeal.
Yeah.
If you would. On the question of attorney's fees.
Yes.
You say the trial court and the magistrate got the number wrong of what you were asking.
Correct.
As I look at the magistrate's decision, the magistrate seemed to have added up, here's all the exhibits, you told that up, it equaled 2019 or whatever it was, but you're saying, no, look, we're asking for 237. Did the magistrate add it wrong, did they miss exhibits, or what happened?
We literally don't know. I've tried to figure out where that number came from. We objected to the magistrate's finding on that because, with all due respect, he's a good magistrate, Mr. Zindel, but he kind of screwed it up a couple of times. First, he came up with a number that was completely wrong. We objected. Judge McLaughlin caught him before that even got really submitted. She struck it. He then came up with this new
On the attorney's fees issue?
Yeah, on the same issue. So if you look at the docket, there was like a prior one that he submitted, but the number was completely wrong. About 3 weeks, a month, maybe it was a month and a half before this decision came down, I do not know where 219,000 comes from.
If I were to add up all the exhibits in the record, I assume here, you would say to me, all our exhibits are in the record.
Correct.
You can add up all our attorney's fees
Correct.
statement, and it should equal 237, whatever
Correct.
your number is.
Correct. So, yeah, I don't know where that number came from, and we tried to raise it to the trial court. She adopted his decision, so I don't know where that number comes from. Real quickly on the attorney's fees issue, there were some odd things that the magistrate did. Number's wrong. Number two, they just categorically denied any cost or expense. So he went through and deducted off of attorney's fees based upon his own determination, but we had like $25,000 of costs and expenses, like court reporting fees and copying fees and subpoena fees and filing fees and parking fees. They just gave us none.
Were
And
they all included on the invoices that were attached?
they are.
Then did at least your client testify these were costs that were needed for?
Correct. So
Did
if you,
anyone else other than your client testify to that?
he testified to it, and then we had Mr. Stephen Dodd came in as an expert to authenticate the reasonableness of the fees, but no third party testified as to the bills.
Did the expert say, I reviewed these costs and they're reasonable?
Yes. Yeah, because one of the questions was like, Veritex is the old Ranillo, the court reporting firm, so they do almost all of our court reporting. And he was like, yeah, I've looked at these court reporting fees, they seem fine. I mean, court reporting is pretty uniform. It's X amount per hour, X amount per page, and unless it's a rush, you know, it's a pretty flat fee. But it seemed like the magistrate was saying, well, you need the bill behind the bill, but that's not how it works. I've been doing this for 30 years. I've never submitted my parking stub in an evidentiary hearing for my attorney's fees as a cost because I charge it straight through to them.
Find you weren't, that the testimony was incredible, or did the magistrate find there was no evidence to support the request? Do you recall from that?
I don't think he addressed it either way. The costs were just not included, which was odd. So,
On your claim for injunction,
yes,
the magistrate seemed to say you fail, one, because the idea that the First Amendment doesn't permit you to do this, but also on the third and fourth prong of the injunction test, it seems to me. Did you argue that the magistrate was wrong on the third or fourth prong?
yes.
Okay.
Yeah, so,
Okay.
yeah, so setting aside the attorney's fees, which is, I don't know why there were these cuts from it.
You have about 1 minute left. just
Yep,
so you know.
I got you. Real quickly, the settlement says any and all costs, attorney's fees, expenses, damages incurred in defending or enforcing the settlement agreement. So there's no limiting language in the settlement. On the injunction, I know I'm running out of time, they argue that it violates the First Amendment. False. That to get an injunction saying, hey, listen, you can't disparage Mark Niederst, doesn't violate the First Amendment. You can waive your right to speedy trial. You can waive your right to parenting a child, your parentage rights. What's more important than that? You can waive your right to a trial by jury. You can waive your right to defense counsel. These are all constitutional rights. You can contractually waive your right to not disparage other people. It happens all the time with divorce cases, SEC cases. Also, we simply ask the trial court, because we're sick of this, we're sick of fighting, we thought it was over multiple times, to enter an injunction, it's in the settlement, enjoining them from filing further actions regarding this dispute. We're not saying she couldn't, if Mark hit her with his car in 2 years, she couldn't sue him. We're saying this dispute is dead and buried, let's put a stake in it. No more lawsuits with regards to this,
And
no more
your
disturbing.
time's up. Just one brief question. The
Sure.
court noted, seemed to note that you didn't include specific injunction language. If I look below, was there a request, a specific language you were requesting to the court for the injunction?
I explained it in the hearing. She never asked, or the magistrate never asked for a proposed order, which we would have been glad to give them.
So there's no proposed order, but you did on the record
Correct.
say we're looking for the injunction to say X, Y, and Z.
Basically, I said exactly what I said here, which is disputes with regards to this former lawsuit and this settlement can't go forward, but it's not a bar to future actions, and this no disparaging comments with regards to him. And
Thank you. Barn, any questions for the rest of the panel? You may briefly conclude.
I'll say, Your Honor. Thank you.
And what I told you initially, please come on, that you would be looking at that top thing. I actually double clicked on the top thing, so please look at the bottom 5 minutes. That will be easier.
I got 5 minutes. Thank you. Thank you very much, Your Honor. The first thing I want to point out is he's talking about lawsuit after lawsuit and all these things. They started the lawsuits. My client did not start the lawsuits. 2016, they started the lawsuit. My client has actually really only filed the one lawsuit that we're here on today. That's the only one that she was the plaintiff in. I also want to talk about the attorney fee issue that he's raising. He didn't prove those things. He told you a couple things that were false. The magistrate specifically said that, and this is a quote, that they had failed, appellees had failed to prove that their attorney fees were the natural and probable result of the breach of the settlement agreement. And the magistrate actually said in his report and recommendation, magistrate's decision, that, hey, I could award 0 fees based on the fact that they didn't prove that it was a natural and continuous part of the breach. They also included in their attorney fees and their claim for attorney fees all sorts of stuff well before the 2022 lawsuit. Things that happened in 2017, 2018, 2019 that weren't a part of this lawsuit. So all of those things just weren't there. Your standard of review on an attorney fee issue is an abuse of discretion. And the courts are all very clear that unless you can find an abuse of discretion, you have to honor the trial court's decision on attorney fees.
Do you
Essentially,
understand how the magistrate got the 219,000 figure as opposed to the 237? Is there some?
I
Okay, go ahead.
I do believe, Your Honor, it's that the magistrate specifically said all of this stuff that happened beforehand isn't applicable in this case. They also tried to include a lawsuit that they filed separately against an accountant that my client wasn't even a party to. They put those fees into this case. And additionally, in regard to their expert didn't testify at all about that all the costs and expenses were reasonable, and the magistrate specifically pointed that out, that they didn't present any evidence of that sort. None of it was there. Additionally, in terms of their claims, one of their appeals is a tax issue and a malicious prosecution. They didn't submit the trial transcript, which would have shown whether or not they had actually proven that information. We didn't have to submit the trial transcript because our appeal is only on the summary judgment. We did file a notice of appeal on a couple issues at the trial court, but we satisfied the judgment, and that mooted those issues, did not moot the issue of the granting of summary judgment. But in fact, you know what it did moot? Is all of their appeal, because they accepted the satisfaction and the monies that were put forward. They don't really even have an appeal. And the J.P. Morgan case says specifically that. If you, even as the appellee, if you accept all the money that satisfies the judgment, which they did, that moots their appeal. The only appeal that really should be before this court is the fact that my client didn't get her day in court. She presented all sorts of evidence. For the trial court to say there was no evidence, my client submitted thousands of pages of documents authenticated by affidavits and all sorts of affidavit testimony saying, this is everything that happened, these are the things that I learned, albeit true. She was saying, hey, I think there's something amiss here. But she, thank you, Your Honor, she repeatedly said, was told, hey, Mark has done everything above board, he did this. Mark was supposed to hire separate counsel to represent these multitude of entities. He didn't do that. So she didn't know the information. And that's the essence of a claim. So the other part about the tender back rule, that applies in cases where I settle a PI case with you and then I try to refute it. I have to give you back the $100 grand that we settled it for. It doesn't apply to this kind of case where tender back would be impossible. They had divided up these companies, they had done all that. I would ask that the court reverse the trial court's grant of the summary judgment and dismiss their appeal. I appreciate your time.
Thank you. And on behalf of the court, I'd like to thank both of you for your presentation today. The court will take the matter under advisement and issue a decision in due course. When that decision is released, the clerk of courts will mail a copy of that to you. It will also be available on the High Supreme Court website. With that, the court is now adjourned until this Thursday, September 26th,